All right, so just a couple of quick ideas here. A test case is a lawsuit that tests the validity of a law or a legal principle. There are many, in most of the cases that we're going to look at here, most of the federal cases, although the story, like Ex parte Crow Dog, the story of the murder of Spotted Tail is interesting. It leads to much larger questions and with great ramifications into the present and into the future. So, oftentimes, and it could be that Crow Dog was snatched up by the Supreme Court to be a test case. It may have been a perfect example of how to extend federal jurisdiction for Congress to extend federal jurisdiction into Indian country, because Congress represents the American people, all right, the non-Indian American people at this point, and because it represents the people, it's political. It goes as popular opinion does to some degree, unlike the Constitution and the courts, which have to interpret, the law of the land, and the law of the land changes, so they have to interpret that too. But anyway.
I was wondering, surely this wasn't the first time this has happened.
Yeah, it was just the first time that it was brought into the system, into the court system. All right. Well, now we're going to talk about, and for some reason I didn't provide italics on this one. Oh my gosh, I can't believe I did that. I'll have to fix that. Okay, so there are three cases that are what your textbook author says or calls the plenary power trilogy. So you've heard of the Marshall trilogy. Now you've got the plenary power trilogy. These weren't decided by the same individual, but they all kind of affirm they affirm different facets of Indian sovereignty, of how we can define Indian sovereignty. So, of course, you're probably thinking the Major Crimes Act is an infringement on Indian sovereignty by the federal government. So, is that constitutional? I tend to think it's not. But in 1886, there was another test case, and this took place in California, United States versus Kagama. And it basically what it did was it affirmed the Major Crimes Act as valid. All right. It basically provided a reasoning on a basis for the Major Crimes Act. Lone Wolf versus Hitchcock, 1903. One of the most important one of the most important federal cases ever for Indian country. It took place in Oklahoma Territory. It involved the Cheyenne and Arapaho reservation, the allotment of the Cheyenne and Arapaho reservation. And what that decided was the Supreme Court or the federal courts recognized that the United States Congress, holds, in other words, Congress says that the United States has the authority to break Indian treaties. All right? Explain why. And then the United States versus Sandoval takes place in the Pueblo area of New Mexico. Yeah, New Mexico. And this answers the question, does the United States have authority over Native Americans who hold U.S. citizenship and live on land owned by their tribe in fee simple? let's think about this last one. Did the United States have authority over Native Americans who hold United States citizenship? Because in 1913, not all Indian people had United States citizenship yet. Most did, probably 7/8, I suppose, maybe 2/3. But the Pueblos sort of interpreted their citizenship as United States citizenship. And it was kind of a funny situation how that happened. And the Pueblos did not live they didn't live in Indian country, they lived on their own land, put it that way. They lived on fee simple land, like the 5 tribes did. But they did not live on reservation land or federal trust land. They owned they have relatively small reservations or areas, and those were owned in fee simple prior to the United States arriving. So let's talk about those. United States versus Kagana. Another murder case, Indian on Indian within Indian country within California. The story of the case has all kinds of errors, but that doesn't really matter because it went to court, and the United States, the prosecution here, argued that the Commerce Clause of the Constitution gave Congress authority over Indian sovereignty. And that's what validated the Major Crimes Act. Here's the majority opinion. I'll link this so you can see it on Justia and Oye. This was the argument, okay, and then it was kind of a well, okay. So basically, the majority opinion of the court said no, the Commerce Clause doesn't give you authority over Indian country, but the Supreme Court of the United States upheld the law, the Major Crimes Act, because at the time it was kind of weak. The court was sort of just deferring to Congress. So it deferred to Congress by stretching the meaning of Marshall's dependency statement. And that's the really important part of this case, is this is when the Supreme Court used dependency to allow Congress to encroach upon tribal sovereignty, or at least the United States to assume ultimate sovereignty over the tribe. Dependency was the word that allowed the courts to interpret it this way. Now, this separated the idea that Indian tribes were kind of analogous to states, because states are sovereigns, they're territorial sovereigns, and because the U.S. Constitution restrains federal power over certain areas of state sovereignty, the courts interpreted the relationship between the federal government and the tribes to be something different. In other words, the tribes didn't have that same kind of sovereignty protected by the Constitution that the states did. Okay? It's a little convoluted, but once you read the opinion, and you read it in the text, the interpretation of the text, it's good. There's not a lot of specifics on the case. So let's move on. Oh, here's some more notes. Okay. This is like way too many notes, but and you also get my own opinions here. Kagama, by affirming the Major Crimes Act, sort of opened up Indian country to all sorts of other incursions by the federal government. So plenary power over Indian tribes was not based in the Commerce Clause, but in the interpretation of Indian tribes as domestic dependent nations, as basically dependent wards of the state. And that dependency status allowed more and more unilateral decision making by Congress without, bothering to respect the tribes themselves. Okay, so anyway, 1886, and then next year you get the Dawes Act, 1887. A lot of legal scholars have said it's actually an embarrassment to constitutional theory, the way this was argued, but it remains in place. So it's bad law, but it's law. There is such a thing. I can't force you to take these off, or I'll get fired. Okay, that's the latest rumor I've heard. But by law, I can't demand that you have a mask on. Frankly, I don't think myself. I think we're probably safe, but I can't demand that you do that because I'm a state employee and I want to remain a state employee for a while. This particular case, U.S. versus Kagama in 1886, is related to another case that you'll read about called, basically the Tehit-Ton case of 1955, deals with a small group of people in Alaska, and it gets a little bit more complex than that. All right. This is taken directly out of that opinion. So have a look at this. Okay. This is part of the concurring opinion of the case, and basically you can see that the court holds tribes to be essentially weak and helpless, so the federal government has to step in to protect them from the states. Okay, now one of the most notorious cases of all. Lone Wolf versus Hitchcock. Lone Wolf was an elder of the Cheyenne. And the Cheyenne Arapaho Reservation was one of these reservations that dropped more than one tribe into an area. So we can say the CNA reservation or something like that. But Hitchcock was Secretary of the Interior, Ethan Allen Hitchcock. He didn't have anything to do, with the case. It's just, this is basically the Cheyenne Arapaho tribe suing the Department of the Interior, basically trying to get some recourse from the federal government for wrongs done to them by the federal government. Now, you've probably heard of the Jerome Commission, perhaps. It was formerly, the formal name was the Cherokee Commission. It was run by a fellow by the name of David Jerome, who was the chief negotiator for the Indian Office to win allotment agreements, to negotiate allotment agreements with the tribes. I don't know why they call it the Cherokee Commission, because they didn't work in the Cherokee Nation. They worked in the central and southwestern part of Oklahoma Territory and the Plains tribes. The 1867 treaty that the Cheyenne and Arapaho signed when they agreed to move to their reservation in Oklahoma. Remember the name of that treaty? You should, because it's going to be on the test. 1867. There's one in 1867 and one in 1868. Both involved Plains tribes. The 1867 treaty was negotiated in Kansas at where? Medicine Lodge. Ever heard of Medicine Lodge, Kansas? Or sometimes it's referred to as the Medicine Lodge Creek Treaty, or Medicine Lodge Treaty.
I just got to the page.
Okay, I'm sorry. What about the 1868? That involved the Northern Plains, Lakota.
Second Treaty of
That's right.
Laramie?
Yep, Second Treaty of Fort Laramie, good. So those are the two treaties taking place during the so-called Indian Wars on the Plains that established these reservations. Well, the Cheyenne and Arapaho signed a treaty, and the provisions of that treaty dealt with allotment, because allotment was on the minds of the federal government. Okay, and according to the provisions of the Treaty of Medicine Lodge, the Cheyenne demanded that no allotment would ever take place without a signed approval of 3/4 of the men of the tribe, 75% of the population, of the male population of the tribe. And that was in the treaty. Okay, so they had a good provision there, right? They put a little insurance policy in that, okay, if this is our reservation, we're going to make sure that the government just doesn't come take it away from us. Doesn't sound like dependent wards of the state to me. Sounds like pretty shrewd negotiators in 1867, right? All right, anyway, the negotiation between the Jerome Commission, or the Cherokee Commission, and the Cheyenne Arapaho representatives in the 1890s, this is much later. Remember after the Dawes Act, the 5 tribes were exempt from the Dawes Act, so the government began working on the smaller reservation groups in central and southwest Oklahoma, and north central Oklahoma. You know, the majority of the 39 federally recognized Indian tribes we have.
Did we go over those 2 treaties in class?
Excuse me?
Did we go over those 2 treaties in class?
Did we?
Yeah, it was on like 7th of September.
When we talked about it in class?
Yeah.
Yeah, it would have been in the removal, it would have been in the chapter on reservations. That's that chapter that I said was way too long and kind of disparate. The chapter should be 4. Yeah, chapter 4, I think.
I don't have it.
Yeah, we'll talk more about them, and I'll link the link the treaty for you if you want to read it. We probably ought to read this one, just see what it says. But anyway, the treaty negotiations, at least as claimed by the Cheyenne and Arapaho, and the lone wolf was simply the figure. It had to be a single figure to represent their side. But he was an elder. The Cheyenne and Arapaho claimed that the negotiation was flagrantly fraudulent in a number of ways, and they named them. A, the negotiations for the allotment agreement between the Jerome Commission was made in secret with certain individuals who were on the allotment side. Okay, number one, held in secret, no transparency. B, there were two versions of the agreement, one in English and one in the tribal languages. Okay, and they weren't equivalent. C, some of the signatures on the allotment agreement were obtained under duress. I don't know the details about that, but they claimed to be signed by people who were threatened by the government for some reason or another, or by the negotiators and the Indian agent. And D, many of the signatures were actually forged by the Jerome Commission. Now, this was investigated. It was investigated by the Department of the Interior. And the Department of the Interior, Commissioner of Indian Affairs himself, recognized that this agreement was fraudulent. It was riddled with all sorts of inaccuracies and lies. So it took a while for the Commissioner of Indian Affairs to come to that decision. In the meantime, prior to that decision, allotment went ahead and went forward because the Tri-Arapaho is not that, there are not that many people, lots of land. They went ahead and allotted the lands and opened the surplus lands to white settlement by a land run. So if you're familiar with Oklahoma settlement, the Cheyenne-Arapaho area, the surplus lands area, was opened by a land run in 1892, I believe it was. Maybe it was 1894, I'm not really, maybe it was 93. I think it was 92 or 94. But this case sort of cooked for about a decade. And so about 10 years, and the case was eventually heard by the Supreme Court. And what did they say? The Supreme Court said that, remember, the United States Congress has the authority to abrogate or break treaties. Why do you suppose it did that? It was such a mess. There were so many, you have thousands of people running in and claiming land within the reservation. It was too late. The interpretation by the courts was that Congress isn't perfect, Congress makes mistakes, but Congress doesn't have to correct its mistakes, at least in the case of Indian tribes. It's not obligated to. Sometimes there are mistakes made, but in this case, allotment was done, the surplus lands were opened. And the thing that the United States, the thing that the court said that Congress can do is break an Indian treaty. It violated an Indian treaty. Obviously, it violated an Indian treaty, but it doesn't have to correct it. Now, there are still a lot of people who believe that that constituted a taking, and there are still people trying to develop a case for that in Oklahoma. One time I was doing research in Oklahoma Historical Society back in the 90s. I ran into an individual who was working on a case. He was working on this argument. There are a number of books on this whole thing, on this whole mismanaged mess. Here are some more details on the court opinion. So the trust obligation is used to justify the government's plenary action to allot the land, calling it an emergency. The emergency was, oh God, we already let all the whites take the land. Sorry. So using the trust obligation or this guardian-ward relationship, courts twisted that to favor the guardian's trashing of the treaty obligations. and this is the basic point that I tried to make earlier, the court argued that Congress may ignore the terms of Indian treaty because the terms of an Indian treaty are not legally binding to the United States. That calls Indian treaties political and not legal. Indian treaties are basically no longer the law of the land. All right. That's plenary power, because tribes are now at the mercy of Congress. And Congress basically has no accountability with regard to Indian tribes. The only accountability is popular opinion. Okay? We can probably squeeze in Sandoval real quick. Let's do that. You'll read about it too. This is an 1886 case, kind of interesting in that it involved the Pueblos. The Pueblos held fee simple title to their pueblo from the Spanish. Okay, they were recognized as a sovereign people by the Spanish. The Spanish granted them title to the land. And if you recall, New Mexico, I think I've got notes to this point, but after the Mexican War was over in 1840, was it 48? 1848. The Treaty of Guadalupe Hidalgo. Treaty of Guadalupe Hidalgo was the treaty that passed half of the territory of Mexico to the United States. Okay, the United States conquered it, basically. Now, the United States, in the treaty, gave everybody within the western part of the territory a year to leave or assume that you are United States citizens. Well, the Pueblos never left. They just automatically became United States citizens. And they had ownership. Oh, and also the titles to the titles granted and recognized by Mexico, which were originally granted by Spain, land titles recognized by the state of Mexico would be recognized by the United States. That's in the treaty. Of course, nobody was really thinking about the Indians, and they certainly weren't thinking about the Pueblos because they had a kind of a special relationship with Spain and with Mexico. So the Pueblo lands were. I'm going to skip over this. Is just kind of vague, but there's another case that comes in that has some significance to this, called Indian Country USA versus Oklahoma Tax Commission, and that's 1987. We'll read about that later. Okay. Yeah, I didn't explain too much about that, but essentially what that meant, what that case, the Sandoval case, was about was the Pueblos. Technically, the Pueblos believed they had United States citizenship, and they had title to their land, and therefore they were not subject to United States Indian policy that placed, their sovereignty within the plenary power of Congress. But what happened was the court said, no, you're going to be just like all the rest of the Indians in this country. All right? You're not special, and those your lands, your Pueblos, are now reservation lands. Okay, so it was forcing a square peg into a round hole, pretty much. Okay, well, that's about it. Read those two chapters. That's Plenary Power 1 and Plenary Power 2. And next time, I think we may have caught up. Or we're getting close to catching up, maybe. All right? But I'll have some study questions on there for you, too, and we'll link some stuff. So have a good week. Have a good weekend.
These two chapters basically said, United States says, screw it.
Well, What?
But it looks like these two chapters, they just kind of like say, all right.
Yeah, because you're right. Because, well, it's odd. The Supreme Court at this time was sort of bipolar. All right. In some sense, they were really weak, like Lone Wolf versus Hitchcock. It's just wrong, right? But as we'll see later, when we get to water rights, there was the Supreme Court justice and a Supreme Court justice who really ruled in favor of Indian sovereignty on water rights. Okay, and we'll see that when you get to the Winters rights, which is basically water rights in Indian country. All right, y'all have a good one.